All right, I am ready to begin on Crittenton versus Floyd Healthcare Management, petition for judicial review. Each party has 30 minutes. Whoever is going to begin for petitioner may begin.
Thank you, Your Honor. May it please the court. My name is Joseph Bearden, and today I will be representing the Georgia Department of Revenue. At this time, Your Honor, I'd like to reserve about 5 minutes of my time for rebuttal.
Okay.
Thank you. Your Honor, this case primarily concerns application of the Quality Jobs Tax Credit. While there isn't any real factual dispute that Floyd Healthcare created jobs, the question on appeal is whether Floyd Healthcare, as a tax-exempt entity, is entitled to claim the credit itself. Looking at the applicable laws and statutes, they are not. The Quality Jobs Tax Credit was enacted and has been in effect since 2009, but the Department of Revenue has not had a tax-exempt employer attempt to claim the credit in this manner before. As such, this case is going to be particularly precedential and will determine whether nonprofit hospitals like Floyd can claim the Quality Jobs Tax Credit. Now, initially, Floyd Healthcare brought the department's denial of their claim to the Georgia Tax Tribunal, which ruled in their favor on the grounds that Floyd Healthcare was technically a taxpayer. Today, we're here on the department's appeal of that decision, for which the standard of review for legal determinations is going to be de novo. Now, Floyd Healthcare is already a tax-exempt entity at the state's expense. However, Floyd now seeks to effectively double dip into tax benefits as they're attempting to claim for the 3 years at issue nearly $4 million in Quality Jobs tax credits on top of that tax-exempt status. To do this, Floyd has argued that their unrelated business income makes them a taxpayer. This unrelated business income comes from their third-party lab testing work, and for 2 of the tax years in question, the Starbucks and Subway operations on their campus. However, for the tax years in questions, this is 2014 through 2016, Floyd only paid approximately $77,000 in unrelated business tax, but they're claiming nearly 50 times that amount in credits. The department believes this claim is not in keeping with the intent of these credits. Under Georgia law, any exemption or tax credit must be strictly construed and will not be found unless the terms under which it is claimed clearly and distinctly show that such was the intention of the legislature. That's going to be Georgia Department of Revenue versus Georgia Chemistry Council. And here there's no evidence the legislature intended to allow tax-exempt entities to claim the credit. Floyd's argument has been that the term at issue, taxpayer, is a straightforward term, and the department very respectfully disagrees. The Quality Jobs Tax Credit, which is codified at OCGA 48740.17, defines a taxpayer as any individual who files a return or pays taxes. But the statute does not elaborate on what returns or taxes would be appropriate. For example, it would be unreasonable in this instance to say that a nonprofit entity that just files informational returns is entitled to the credit simply because they technically file an informational return. Therefore, we have to turn to our tools of statutory interpretation. First, we have to look at the rule that the express mention of one thing implies the exclusion of another, which is supported in Alexander Props Group, Inc. versus Doe. Under the statute, the Quality Jobs Tax Credit can be chosen if a taxpayer does not elect to claim any of the 8 other enumerated tax credits in the code section, 40-7-40.17b, all of which apply to majority for-profit industries. And those are specifically manufacturing, warehousing, telecommunications, broadcasting, tourism, research and development, biomedical manufacturing, and services for the elderly and persons with disabilities. Now, the language there about choosing the Quality Jobs Tax Credit over these other credits implies that any entity seeking to claim the Quality Jobs Tax Credit should qualify for at least one of these other credits, which Floyd Healthcare does not. Floyd does not engage in any of these industries. It is a tax-exempt healthcare provider. Second, we can look at the plain meaning of the terms taxpayer and tax-exempt entity and see that these categories would plainly not overlap. Under OCGA 48725, organizations that are exempt from federal income tax are also exempt for the purposes of Georgia income tax and only must file informational returns. As a nonprofit, these returns, do not obligate Floyd to pay any taxes. And again, it would be unreasonable of an interpretation to say that an entity is a taxpayer entitled to the quality jobs tax credit just by filing an informational return that in no way obligates them to pay any tax. Now, Floyd has argued that their filing of unrelated business income returns and their payment of tax on that unrelated business income technically means they are taxpayers. As we said before, between their Starbucks, Subway, and third-party lab testing operations, Floyd only paid about $77,000 in unrelated business tax, while they're claiming nearly $4 million in tax credits. And moreover, none of the jobs they're claiming as quality jobs on their claims come from those unrelated business activities. The jobs they're claiming are all doctors, nurses, hospital admin staff, all of which relate to their tax-exempt activities. From a policy perspective, we're looking at a tax-exempt entity trying to use a technicality to gain access to 50 times the amount of tax they pay in credits. And looking at the specific text of related rules, Department Rule 560-7-8-.51 further codifies the quality jobs tax credit. And in paragraph 7, titled Claiming the Credit, it states that the quality jobs tax credit shall be claimed on an income tax return for the first taxable year in which the taxpayer becomes eligible for the credit. Now, Georgia corporate income tax is imposed under OCGA 48721, while tax on unrelated business income is imposed under OCGA 48725C. Because these two types of returns / taxes are treated differently in the code, we can't say outright that they are interchangeable or that the legislature specifically intended for unrelated business income to act as an access point to the quality jobs tax credit. And again, tax credits must be strictly construed. So we can't say that Floyd Healthcare is entitled to the credit based simply on the fact that they technically pay a tax when that tax isn't even typical business income tax. At the absolute most, even if Floyd is technically a taxpayer, Floyd should only be allowed to claim those quality jobs related to their non-exempt income. Here again, the quality jobs tax credit states that those who do not claim the 8 other enumerated credits in that section can claim the quality jobs tax credit. Going back to our rule about how express mentions of one thing imply the exclusion of those things not mentioned, we can say that the credit was meant to apply to for-profit endeavors and the jobs they create. The only for-profit activities Floyd had in the years in question were their Starbucks, the Subway, and their lab testing, none of which were involved in the quality jobs they claimed. Under Floyd's interpretation, as long as they pay $1 of tax, no matter what tax, they qualify as a taxpayer, which is an already unreasonable interpretation, but even more so when it allows them to claim their tax-exempt jobs for millions of dollars of credits while disregarding the unrelated business income that gave them access to the credit in the first place. Ultimately, Your Honor, this case is about a tax-free healthcare entity attempting to double down on their tax-free status and get access to millions of dollars of credits intended for companies that otherwise pay their own income tax. Such an interpretation is not only detrimental to the state, but is clearly not in keeping with the spirit of the tax credit. Thank you.
Thank you, Your Honor. Antoinette Ellison, may it please the court for Respondent Floyd Healthcare. A few things. The department mentioned that, I'll start with, they mentioned the spirit of the statute, and allowing Floyd to claim the credit is not in keeping with the spirit of the statute. There are 5 reasons why the department is unable to establish reversible error, and respectfully, the court should affirm the decision of the tribunal. The first is the department's position that Floyd is ineligible for the credit simply based on its nonprofit status is contrary to the legislative purpose. The second is that under the clear text of the statute, which the department didn't really discuss exactly what the statute says, filing any return or paying any taxes qualifies an employer as a taxpayer eligible to claim the jobs tax credit. Third, the department makes various arguments. It relies on strict construction and says the express mention of one thing means the exclusion of another. I will walk through each one of those, Your Honor, and say why those arguments are wrong. Next, the department says that you have to file an income tax return. It's not enough that you file an informational return or that you file a UBI, a return for payment of tax on unrelated business income. Even if for some reason the language that the legislature used of a return could be read to mean an income tax return, Floyd filed one in this case and therefore is entitled to the credit. And then last, there is no qualifying project requirement or other basis to try to limit Floyd to only claiming the credit for jobs that generate unrelated business income or a particular type of taxable income. Just briefly, there was a discussion made about the amount of UBI tax paid and the amount of credits that Floyd is trying to claim. The point of the statute here is to generate the creation of high-paying quality jobs. And if we look, that's what Floyd did during the 3 years at issue. In 2014, it created 214 high-quality jobs. That number was 247 in 2015, and then increased to 304 jobs in 2016. That brought $56 million in wages to the region. So it's not a matter of trying to double dip or take benefit for credit without providing any benefit to the state of Georgia. So in keeping with the intent of this statute, which was to get employers to invest in Georgia to bring jobs, that's what Floyd did. I sort of lost count on how many times it was said that Floyd is a nonprofit or a tax exempt entity. That doesn't mean it's exempt from all taxes. Yes, the portion of its income that's directly or substantially related to its nonprofit purpose is exempt from tax, but Floyd must pay other taxes. It must pay tax on withholding, the amount of wages that are held back and paid to the state. It does have to pay income tax on its unrelated business income that's not directly related to its non-exempt purpose. And along with those payment obligations, it has filing obligations. So yes, it does file federal informational returns, but it also files withholding tax returns and UBI or unrelated business income tax returns. On page 1 of our brief, Your Honor, we talked about the purpose of the statute. It was introduced by then Representative Larry O'Neill, now Chief Judge of the Tax Tribunal. And the purpose is so that business will receive a benefit for establishing jobs that pay a high wage, higher than the average wage for the county. And that was to bring about stability and to help Georgia as it seeks to move forward as a competitive force. Under the department's position, there was mention that a company Floyd could pay $1 tax and then seek to claim millions of dollars in credits. But under the statute, as it's written, you can have a for-profit company that pays absolutely $0 in tax because it operates at a loss, never incurs any income tax liability, and there's no dispute from the department that that company would be eligible to claim the credit. Simply because Floyd is a nonprofit, then it's categorically ineligible, no matter how many jobs it brings to the region, no matter how much money it contributes, and no matter how much tax it pays, be it withholding tax or be it tax on unrelated business income. And it's our position, Your Honor, that that just is not a reasonable result, particularly when the goal was to get all companies, all employers to generate jobs in the area. And if the legislature intended to treat for-profits substantially better than non-for-profits, one would expect the legislature to be explicit on that point, but there's no sort of reference to for-profits or nonprofits in the statute. If I may, I would like to briefly share my screen just so that we can look at the text of the statute, please.
Go right ahead.
Thank you. Are you able to see my screen, Your Honor?
I am.
Okay, so here we have the text of the statute, and there are 3 requirements. The first is that the employer must be a taxpayer, and yes, it must elect not to receive one of these 8 other credits enumerated in these code sections listed here. And then the employer must establish or relocate at least 50 quality or new quality jobs in the state. We look at the next portion of the statute. So the statute explicitly says that first, the credit is taken against income tax, but then where the amount of the credit exceeds a taxpayer's liability for income taxes in a taxable year, the excess may be taken as a credit against such taxpayers' quarterly or monthly payment under Code Section 487103. And that is the employer's liability to pay withholding. So you can have an employer, as I mentioned, who operates at a loss, pays absolutely no income tax, and can claim the credit against withholding. The key requirement that's at issue here is that the employer must be a taxpayer. And the legislature has defined taxpayer in the statute. And it means any person required by law to file a return or to pay taxes. This is a disjunctive definition, so either one, filing the return or paying the taxes, qualifies you as a taxpayer. Respectfully, the department talked about rules of statutory construction. The first is that you cannot, by construction, add to, take from, or vary the meaning of unambiguous words in a statute. At no point in briefing below or before this court has the department ever said that this language is not clear or that the statute is ambiguous. And so, absent any language of limitations specifically requiring a specific type of tax be paid or a specific type of return be paid, it was reasonable for the court below, the tribunal, and for this court to presume that any return or any taxes qualifies one as a taxpayer eligible to claim the credit. And there's no dispute that Floyd was required to pay taxes. As discussed, it did have unrelated business income on which it paid income tax. It also had to pay withholding tax. Code section 48-7-108 says that an employer shall be liable for the payment of tax required to be deducted and withheld under this article, whether or not the employer has deducted and withheld the tax. And Floyd's obligation to pay tax on UBI is under Code Section 48-7-25. And the parties stipulated below, there's a joint stipulation of fact that Floyd was required to pay these taxes. There was mention that the general corporate income tax is under Code Section 48-7-21, whereas the tax on unrelated business income is under 48-7-25. That's a difference that basically, Your Honor, doesn't matter. They're both under Chapter 7, Article 2. They're both types of income tax. And so even if for some reason the words taxes in the statute could be read as requiring the payment of income taxes, Floyd has paid income taxes and is therefore a taxpayer eligible to claim the credit. If we look at whether or not it filed a return, the department has admitted that it filed Federal Form 990, 990T, that it has filed Georgia Form 600T for its payment of tax on unrelated business income. And of course, Floyd was required to pay withholding return, or excuse me, to file withholding returns. And that obligation to make that filing for the withholding returns is under Code Section 48-7-103. So looking at the plain language of the statute against the undisputed facts, Floyd falls within the meaning of a taxpayer, either because it paid taxes or because it filed returns. The department also referred to the 8 enumerated statutes that we saw in the text of, or the 8 enumerated credits that we saw in the text of the statute, and said that they're an alternative and that one must qualify not only for the quality jobs tax credit, but also one of those other credits. That's not true, Your Honor. Those credits are listed there simply to say that jobs that are counted for purposes of claiming the quality jobs tax credit cannot then be used to claim another credit. So on that point, we agree. There shouldn't be double dipping in terms of trying to claim additional credits, but that's the only reason why they're listed in the statute. If we look at the department's final decision, because the department below, I think I said the department, if we look at the tribunal's final decision, the department raised these 8 credits before, and the department, the tribunal on this issue had this to say: the final fact that the department points to, let me step back. So after the tribunal issued its order on the threshold issues, the department then tried to revisit that ruling and said that there were new facts that came out in discovery that showed that Floyd and other nonprofits aren't entitled to claim the credit. And one of those facts that the department pointed to was that Floyd could not have claimed any of the other tax credits listed in 48-740, 40.1, 40.2, 40.3, or 40.4, 40.7, 40.8, or 40.9, and that it wasn't a business enterprise and that it didn't engage in for-profit business activities, quote unquote. The tribunal said this fact is not relevant to the questions that were the subject of the threshold issues. The only requirement stated in the quality jobs tax credit statute regarding those 8 enumerated job tax credits is that a taxpayer must elect not to receive any of those credits. And it basically said you don't have to qualify for one of those. If you did, if you sort of follow the department's logic that you must not only qualify for the quality jobs tax credit, but one of those other enumerated credits, if you look at them, as the department admits, those credits explicitly limit the activities to manufacturing, to telecommunications, to broadcasting. And so under the department's position, even for-profit companies that don't engage in those specific activities would be excluded from the credit. And that's an unreasonable result. So if you had a law firm that wants to move to Georgia, wants to bring you high quality jobs, it's not engaged in telecommunications or broadcasting or manufacturing, and so it couldn't qualify for the credit. That's not what the legislature intended. It didn't mean that you had to qualify for 2 of those credits and then elect only to pick one. It basically was, you can't get both if for some reason you were to be eligible for multiple credits. On the last point about trying to limit the jobs just to, I'm sorry if I step back again, 1 second, Your Honor. I think also it was said that those other credits are limited to only for-profit activities. Of course, we set forth examples in our brief as to why that's not correct. We're all familiar with NPR. It's a nonprofit. It engages in broadcasting, which is one of the activities in the other tax credits. And so you can have nonprofits that engage in those activities. So there's no validity to the argument that only for-profits can conduct the activities in those 8 enumerated credits. On the last point, because the department essentially realizes that that there really is no validity, or that its position that Floyd is not a taxpayer is baseless, it then tries to limit the amount of credit that Floyd can take and say that only jobs that generate unrelated business income should be entitled to the credit. Again, I go back to my example of if you have a for-profit company that operates at a loss, it doesn't have to show that any of its jobs produce any sort of taxable income in order to be entitled to the credit. And there's no basis for saying that there's some sort of qualifying project requirement, or that the legislature didn't intend for jobs that didn't produce a certain type of income in order to be able to take the benefit of the credit. So if we go back again, Floyd is a taxpayer. It paid tax, withholding tax. It paid tax on its UBI. It pays other taxes. It filed returns that fall within the common meaning of the word return, as the department admits can include informational returns. And so there's no basis to say that Floyd is not a taxpayer, or that its credit that it can claim should somehow be limited to a small number of jobs, or jobs that produce a particular type of income. Thank you, Your Honor.
Okay, thank you. Mr. Bearden, rebuttal.
Thank you, Your Honor. Floyd Healthcare already enjoys a tax-exempt status. This is a very significant benefit considering their income, and it comes at the expense of the state and taxpayers. Compared to for-profit companies, Floyd has a massive advantage. And even if Floyd pays some tax in the form of unrelated business income, that doesn't mean the legislature intended for entities like Floyd to have the double benefit of being a tax-exempt entity and claiming the quality jobs tax credit. Again, we have to strictly construe tax credits, especially when it's the state and taxpayers that have to bear the burden of supporting these entities. And even then, the issue still exists that Floyd is asking to use their technical status as a taxpayer, if that's the case, by virtue of their UBI income to exclusively claim quality jobs related to their tax-exempt employees. There's no indication in the statute whatsoever that this sort of loophole where you're allowed to technically qualify by virtue of one tax, then to claim completely tax-free employees as quality jobs. There's no indication that that was part of the legislature's intention. It has to be plainly stated, and it's the department's opinion that it's just not, and they can't support that claim. Thank you, Your Honor.
All right, thank you very much. I don't have any questions. So I will take it under advisement, and we will contact the prevailing party to get a proposed order at the appropriate time. All right, well, thank you all, and you are free to log off.
Thank you very much.